Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuhu. Welcome to this course on Islamic inheritance law. In this session, we shall be looking at the duties to be performed for a deceased Muslim. Let's start off with text from the Sirajiyah. قال علماؤنا رحمهم الله تعالى تتعلق بتركة الميت حقوق أربعة مرتبة. الأول يبدأ بتكفينه وتجهيزه من غير تبذير ولا تقتير، ثم تقضى ديونه من جميع ما بقي من ماله، ثم تنفذ وصاياه من ثلث ما بقي بعد الدين، ثم يقسم الباقي بين ورثته بالكتاب والسنة وإجماع الأمة. After a Muslim individual passes away, there are four rights that must be fulfilled from his or her estate. First, his funeral and burial expenses must be paid. Second, all of his debts are settled. Third, any valid bequests or legacies, up to 1/3 of what remains, are honored. Finally, the rest of the estate is distributed amongst the heirs in accordance with Sharia. In principle, the funeral and burial expenses should be paid from the estate of the deceased. If the person left sufficient wealth, the costs of shrouding, washing, the janazah, and burial are taken from that estate before debts, bequests, or inheritance are dealt with. Historically, within the Muslim Ummah, it has also been common for relatives or the wider community to assist with these expenses, especially where the estate is small or non-existent. In all cases, the funeral should be conducted with dignity, neither wastefully extravagant nor miserly and unduly minimal. According to the Hanfi fiqh, in the well-known view attributed to Imam Abu Yusuf, the husband is responsible for the basic funeral expenses of his wife, because he was obliged to maintain her during her lifetime. If she leaves her own estate, that estate still bears the general obligations in order: necessary funeral costs, then debts, then bequests, and only then distribution among the heirs. In the other schools of law, the basic principles are similar. If the deceased leaves wealth, the funeral and burial are paid from their own estate before anything else. The Maliki and Shafi'i jurists, like the Hanfis, generally hold that the husband must cover his wife's shrouding and essential funeral costs because he was obliged to maintain her in life. The Hanbali school, however, tends to give more weight to paying these costs from the wife's own wealth if she leaves an estate, although many contemporary scholars still recommend that a financially able husband should not shy away from meeting these expenses. Regarding payment of debts of the deceased, the scholars generally agree that any outstanding obligations to Allah subhanahu wa ta'ala, such as unpaid zakat, an unperformed obligatory hajj, or due expiations, should be taken seriously and, where possible, discharged from the estate, usually from within the bequeathable 1/3 if the deceased has directed this in the will. At the same time, there is a recognized difference of opinion among the jurists about whether such debts to Allah are automatically binding on the estate if the deceased did not explicitly mention them. In the Hanfi fiqh, a key position transmitted from Imam Abu Hanifa, rahimahullah, is that these obligations are acts of worship that require intention. Therefore, if the deceased clearly instructs in will that fidya for missed fasts or prayers, unpaid zakah, or a missed hajj should be paid, this is carried out from the bequeathable 1/3 of the estate. If no such instruction is left, they are not strictly taken from the estate as a legal obligation, although the heirs are encouraged, as an act of goodwill, to fulfill them from their own funds, or, with the consent of all adult heirs, from more than 1/3 of the estate. By contrast, debts owed to people never lapse with death. These must be settled in full from the estate after funeral expenses and before any inheritance is distributed. After the funeral and burial costs have been paid and all debts of the deceased have been settled, the instructions in the will are then carried out. Any valid bequests are honoured from up to 1/3 of the net estate, that is, from what remains after paying funeral expenses and all debts, while the rest of the estate is reserved for the heirs. Once funeral expenses, debts, and any valid bequests have been dealt with, whatever property remains must be distributed according to Sharia. This involves two key steps. First, identifying all relatives who are legally entitled to inherit, and second, calculating the precise quantum share that each of those eligible heirs must receive. This brings us to the end of this session. Insha'Allah, see you in the next one.